Chamber back to order. Mr. Secretary, can you please read the caption of Senate Resolution 844?
Senate Resolution 844 by Senator Miller of the 49th and others. A resolution honoring the life of Deputy Nicholas Blaine Dixon and dedicating a bridge in his memory and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Transportation recommends that this resolution do pass by substitute. Respectfully submitted by Senator Beach for the 21st chair. Mr. President, the Senate Committee on Transportation offers the following substitute to Senate Resolution 844, a resolution dedicating certain portions of the state highway system for other purposes. Whereas the state of Georgia lost one of its finest citizens and most dedicated law enforcement officers with the tragic passing of Deputy Nicholas Blaine Dixon on July 8th, 2019, and for other purposes. That completes the order, Mr. President.
Chair recognizes the pro tem to speak to Senate Resolution 844.
Thank you, Mr. President. We have a road naming bill before us, Senate Bill 844, and usually this is a very typical, very mundane procedure, but this year's road naming bill has been named for Deputy Nicholas Blaine Dixon. Deputy Dixon had attempted to pull over a car of suspected individuals involved in home burglaries and automobile burglaries and a theft of a large number of firearms. The car fled. There was a crash. The occupants jumped out. Deputy Dixon gave pursuit on foot, and after giving several verbal commands for the offender to show his hands, the offender ran behind a residence and suddenly appeared and opened fire on Deputy Dixon. Deputy Dixon was struck by one round below his bulletproof vest, and his fellow deputies transported him from the scene to Northeast Georgia Health Medical Center in Gainesville, where he later died that evening. Deputy Dixon left behind a history of service to his fellow man. He left behind a history of dedication. He left behind a history of protecting those individuals who are vulnerable. He was a gentleman who was involved in his community. He was a mentor to many young men in our community, and a bridge in North Hall County will be named in his honor. And I think we spoke earlier in the session about structures in our society and about how they have significance and meaning and purpose. And that structure, that bridge in Hall County, has significance and meaning and purpose and history and should be honored, and as should the memory of Deputy Blaine Dixon. If you look at the bill, you'll see other individuals, notable Georgians who have served others. Among those were Tom Price. There are others. But I would ask my Senate colleagues for their favorable report on Senate Bill 844. And before I'd leave the rostrum, I would like to thank the senator from the 21st, our transportation chair. I'd like to thank the senator for naming this bill for Deputy Dixon. Mr. President, if there are no questions, I will yield the will.
You have no questions.
Thank you.
Does any other senator wish to speak to Senate Resolution 844? The chair sees none. The question now is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the adoption of the resolution? Chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question is on the adoption of the resolution by substitute. All those in favor of the resolution will vote yea. Opposed, nay. The secretary will unlock the machine. On the adoption of the resolution, the yeas are 53, the nays are 0. This resolution receiving the requisite constitutional majority is therefore adopted by substitute. If I could have everyone's attention for a moment. During the lunch break, I had a very good meeting with the governor and with the Speaker of the House to talk about developing situations around the coronavirus. And it is an ongoing situation that we're continuing to monitor very closely. I wanted to inform this chamber that in the coming hours, in the next few hours, we should have a more definitive solution about potential adjustments to our upcoming schedule. So just want to give you the most up-to-date information as possible. We're going to continue as is for the time being, and in a few hours, we'll be able to give you more information. Thank you. Ms. Secretary, can you please read the caption of Senate Resolution 885?
Senate Resolution 885 by Senator Harper of the 7th and others. Resolution proposing an amendment to the Constitution so as to authorize the state to incur general obligation debt in order to make loans or grants to certain counties, municipalities, consolidated governments, and local authorities that own airports for the acquisition, construction, development, extension, enlargement, or improvement of such airports and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Transportation recommends that this resolution do pass by substitute, respectively submitted by Senator Beach, the 21st chair. Mr. President, the Senate Transportation Committee offers the following substitute to Senate Resolution 885. A resolution proposing an amendment to the Constitution so as to authorize the state to incur general obligation debt in order to make loans or grants to certain counties, municipalities, consolidated governments, local authorities, and local commissions that own airports for the acquisition, construction, development, extension, enlargement, or improvement of such airports and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 7th to speak to Senate Resolution 885.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I don't think it's any secret that airports and the funding of capital projects for airports across our state has been a passion of mine, as well as a passion of many others in this chamber, including the senator from the 31st and many of those of us who are pilots especially. And over the last few years, we have looked for ways to continue to find a way to address the funding needs of our airports across our state. Our airport network is very important to our state. Our airport network is especially important in rural Georgia. And the reason it's more important in rural Georgia is because that's how we can continue to build on economic development and economic opportunities in that part of the state. Many of you know that the Department of Transportation has a list of over $250 million in outstanding airport projects that we need to address and need to work on going forward. And so we're trying to look for different tools in the toolbox to put in the toolbox to help make that happen. And that's what Senate Resolution 885 tries to do. It gives us the opportunity to amend our Constitution to allow the state of Georgia to take on bonded debt for the purposes of raising funds to fund projects for local airports across our state. We have tried many different measures and many different ways to try to get funding for our airports, but this is just one tool for that. It isn't the silver bullet, but I believe this is a step in the right direction, and I appreciate your favorable consideration. If there are no questions, Mr. President, I will yield the will.
You have no questions. Does any other senator wish to speak for or against Senate Resolution 885? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question is on the adoption of the resolution by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the adoption of the resolution by substitute, the yeas are 54, the nays are 0. This resolution receiving the requisite two-thirds majority is therefore adopted. For what purpose does the majority leader rise?
Thank you, Mr. President. I move that the Senate table all bills and resolutions remaining on the rules calendar.
Is there objection? There is objection. All those in favor of tabling the remaining bills and resolutions on the rules calendar will vote yea. Opposed, nay. The Secretary will unlock the machine. State your inquiry.
Parliamentary inquiry, Mr. President.
State
Could the
your inquiry.
majority leader in a parliamentary stance inform us why this is being done?
Looks like the majority leader's headed your way. That motion is not recognized. On the motion that the Senate table all the bills and resolutions remaining on the rules calendar, the yeas are 49, the nays are 5, and the motion has carried. Who am I recognizing? You're going to read the captions on each 5 or just... He's going to take 5 at a time off the table. So the agreed upon, we can talk about because the agreed upon. Dugan, you ready? Chair recognizes the majority leader.
Thank you, Mr. President. I move that we move Senate Bill 426, Senate Bill 408, Senate Bill 40, Senate Bill 410, and Senate Bill 411 off the table.
Stand by.
Unfortunately, as you know, I can't move all 5 off the table at one time. So you know what my intent is coming up in the sequence, but for this time period, I would like to remove Senate Bill 426 off the table.
Is there any objection to taking Senate Bill 426 off the table? The chair hears none, and the motion carries. Mr. Secretary, can you please read the caption of Senate Bill 426?
Senate Bill number 426 by Senator Strickland of the 17th and others. Bill to be titled an act to amend Article 1 of Chapter 9 of Title 12 of the OCGA relating to air quality so as to provide for the reporting of any unpermitted release of ethylene oxide to the Environmental Protection Division of the Department of Natural Resources and for other purposes. Mr. President, the Senate Committee on Natural Resources and the Environment offers the following substitute to Senate Bill 426. Bill to be titled an act to amend Article 1 of Chapter 9 of Title 12 of the OCGA relating to air quality so as to provide for the reporting of any spill or release of ethylene oxide to the Environmental Protection Division of the Department of Natural Resources and for other purposes. That completes order, Mr. President.
Chair recognizes the senator from the 17th to speak to Senate Bill 426.
Thank you, Mr. President, members of the Senate. I bring you Senate Bill 426, ethylene oxide. Like a lot of y'all, until last summer, I read an article about this chemical. I'd never heard of this. And like so many folks in our state, we first learned about the use of this chemical and how it affects our neighborhoods through an article we read last summer that was published. This created a lot of uncertainty for people. A lot of folks didn't know if they could trust the EPA, the EPD, their state government, the companies that are using this chemical. And since that time, we try to figure out a way to build that trust back and to make sure we know at the state level we have oversight over what's happening at these facilities. With Senate Bill 426, what we're codifying is that any spill or release of ethylene oxide will be sent immediately to the EPD. They'll be notified immediately when there's a spill or release from any of these plants. And second, EPD will immediately take that information and share it on a public website for everybody to see. Gone will be the days where people have to send open records requests to find out what's happening with this chemical. We know, especially given where we are today, the importance of ethylene oxide. We know the importance of making sure we have medical equipment for our hospitals. We also need to make sure that we know what's happening with these facilities in our backyards, in particular in Smyrna and in Covington, where I represent. And I want to thank my colleagues for working with me on this issue, not just in the Senate, but also in the House, and of course the governor for his leadership on this. In particular, I want to point out the senators from the 33rd, 43rd, 48th, and the 6th on the other side of the aisle for working with me to make sure this bill was a bipartisan bill. I think we all agree that when it comes to something like this, we shouldn't care about who gets the credit, because our citizens don't care about who gets the credit for this. And it was important that we did this in a bipartisan fashion, and I want to thank you all for your support. And I'll be happy to answer any questions on Senate Bill 426.
You have no questions, Senator.
Thank you. I'll yield the well.
Chair recognizes the senator from the 6th to speak to the bill.
Thank you, Mr. President. I just wanted to thank the senator from the 17th. My district has been incredibly impacted by the release of ETO, and people are scared and they're upset. And one of the things that we have to do is really rebuild trust in terms of the community. And so what this is going to do is whenever there's a release, it's going to go on the website so people can, because let me tell you something, they're sending Open Records Act requests every single day to EPD because they don't trust the process right now. So this will relieve EPD from having to respond to those, and at the same time, we'll have the information that the public can look at any time or at any point. So I appreciate the efforts of the senator from the 17th and for coming together, because I think that this is an important bill. Thank you.
Senator has yielded the well. The chair recognizes the senator from the 25th to speak to the bill.
Thank you, Mr. President. I just wanted to echo, similar to what the senator from the 6th had to say. I want to thank the senator from the 17th. What's been lost a lot in the conversation about this particular exposure is there's a Cobb County location. There's also a Newton County location, but there is a location in Morgan County as well that has experienced the same type of public concern that I know the senator from the 17th and 6th and a lot of others feel as well. So I just rise in support of this measure by the senator from the 17th and hope that this body will consider favorable for this particular legislation. Thank you, Mr. President.
Senator has yielded the well. The chair recognizes the senator from the 48th to speak to the bill.
Thank you, Mr. President. There's no limit to the good you can do if you don't care who gets the credit. That is a quote that I was required to learn while a cadet at the Air Force Academy. And in the military is a quote that everyone follows. They work hard for the team. This is an example of that kind of work. As a member of the Natural Resources Committee, I thank all the senators on both sides of the aisle who've worked on this issue very diligently, as well as the governor and his staff and his floor leaders. I am proud of the transparency that we've been able to bring for the people of Georgia to be able to know what's going on in their communities and be able to rebuild trust, because the trust has been broken with respect to ethyl oxide. I encourage you all to vote for Senate Bill 426, and again, I appreciate all the good efforts on behalf of the state of Georgia. Thank you, Mr. President. I yield the will.
Chair recognizes the senator from the 33rd to speak to the measure.
Thank you, Mr. President, my fellow senators, colleagues, friends, and y'all. I just want to take time out to thank the senator from the 17th. When I approached him about this bill, he was willing to take a look at what we were talking about and work together in order to get this bill done, because it affects a lot of people, hundreds and thousands of people's lives. So I just want to really commend him for working together with us in a team spirit manner and putting good policy, taking that beyond just regular old politics. Thank you.
Senator has yielded the well. Does any other senator wish to speak for or against Senate Bill 426? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. For what purpose does the senator from the 17th rise?
I move that Senate Bill 408 be taken off the table.
Mr. Secretary, can you please read the caption?
Senate Bill number 408 by Senator Strickland of the 17th and others. A bill to be titled an act to amend code section 34.110 of the OCGA relating to use of sick leave for care of immediate family members so as to repeal sunset provision and for other purposes. Mr. President, if I could please order, Mr. President. Senator from the 17th has asked that Senate Bill 408 be taken off the table. Is there objection? The chair hears none, and Senate Bill 408 is taken off the table. The chair recognizes the senator from the 17th to speak to Senate Bill 408.
Thank you, Mr. President. Friends of the Senate, I bring to you Senate Bill 408. In 2017, this body passed a bill that said that private employees of private companies could use a portion of their sick leave days to care for other immediate family members that are also sick. When that bill passed the Senate with the pro tem carried it, I carried the bill in the House. And as part of the process with that bill, some people said, if you do this to business in our state, there'll be consequences from that. This could actually be bad for business. A state that's been #1 state in which to do business, if you tell employers to a certain extent what they have to do with employees, it can negatively affect our business. And those of us that supported the bill said, no, you're wrong, this is actually good for business. But as a compromise, we added a sunset. Well, the sun will set on this law July 1st of this year, and Senate Bill 408 simply removes that sunset and leaves this in existing law. What we've seen is by allowing employees to use a portion of their sick leave days to care for other family members that are sick, we found that's actually good for business in our state. Once again, year after year, our state still the #1 state in which to do business. And we found that this makes it easier for folks that are single parents or caring for an elderly parent at home or just caring for a child at home to actually have more flexibility and work more days. And as we said back in 2017, this bill is really about not having to lie to your employer. You can tell the truth about why you're having to take sick leave days. We got to care for somebody else at home. And so with that, Mr. President, I ask for your support of Senate Bill 408 and happy to answer any questions. Yes. There also is an amendment, and this just clarifies what was a little bit concerning after I passed it in committee. We didn't have an effective date. And so you may have an issue about when the sun sets July 1st, will the bill be effective yet? And so the amendment makes it clear that this bill become effective when the governor signs it.
You have a question.
I'll yield.
Chair recognizes the senator from the 31st for a question.
Thank you, Mr. President. Does the senator yield?
Yes, sir.
If this is good for business, why do we have to put it in the law?
Well, there are certain things, we pass laws all the time that ought to be common sense, right? I think there's certain things that ought to be standards in our state. One of the biggest issues we now see is trying to find a qualified workforce. And to me, one of the things you can do is to make sure you have laws in our state that are friendly, not just for building business, but also for working for businesses in our state. And so I think it sends a message that we're a place that is not only just friendly to start a business and to have a business, but also to work for a business.
Thank you.
Thank you.
Do you continue to yield?
Yes, sir.
Chair recognizes the senator from the 46th for a question.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Does this apply to private businesses as well as governmental entities?
It does not apply to governmental entities, it just applies to private business.
So we're going to make private businesses give family leave if they give any leave, and this would be unpaid leave
Well,
if they want to do business in the state of Georgia.
No. So this is current law, and what the current law says is that if you offer sick leave, you have to allow up to 5 of those days to be used for caring for other people in your family. So it's not actually requiring more leave. It's giving you flexibility with the leave that you have, and it's recognizing the fact that so many folks are trying to work on raising families, taking care of other people at home. And so no, it's not adding any additional leave. It's providing more flexibility with leave that's already there.
Senator, further yield.
Yes.
But if you give leave of any sort, you would now have to give it for family leave. Couldn't that effectively deter some businesses that are granting leave now from continuing to do so? And you said it's not new law, but this law expires June 30th, so beginning July 1st, it will be extending this principle, right?
Well, you're still not saying it correctly, though. This does not give new family leave. This is allowing you to use up to 5 days of your existing sick leave. But I'd say this, if we think this is detrimental to our businesses, then you have to look back the last few years and find examples of that. I have not heard from a single constituent, business owner, anyone in our state, frankly, that said this bill deterred any sort of business or hurt any sort of business in our state. And the alternative, I've heard from folks that have used this law and have found that it creates more flexibility with caring for their families.
You have no more questions.
Thank you. I'll yield the well.
Does any other senator wish to speak for or against the bill or the amendment? The chair sees none. All right, we're going to take up amendment number 1. Is there objection to adopting amendment number 1? The chair hears none, and amendment number 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 50, the nays are 6. This bill having received the requisite constitutional majority is therefore passed as amended. Chair recognizes the majority leader. Mr. Secretary, will you please read the resolution?
House Resolution number 1473 by Representative Burns of the 159th and Jones of the 47th. Resolution relative to meetings and adjournments of the General Assembly and for other purposes. That completes the order, Mr. President.
Chair recognizes the majority leader to speak to the resolution.
This is the point where I promise you this is going to be the last time we're going to do this. But since the senator from the 53rd has passed his no lying bill, I'm going to say this is the newest version of it. What we have agreed with the House to put both calendars, adjournment calendars, on one piece of legislation so there's no confusion moving forward. The dates that that impact on us in Part 3 are the same ones that we have voted on already unanimously. So you will notice that there's an addition of language in Part 5. That's for the current situation that we're in. Since there are no questions, I yield the well.
Senator has yielded the well. Does any other senator wish to speak for or against the resolution? Chair recognizes. He waives. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The question is on the adoption of the resolution. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. I do completely agree. All right, you're on Senate Bill 40? Yes, sir. Okay. Yeah, he had his button pushed. On the adoption of the resolution, the yeas are 53, the nays are 1. This resolution, having received the requisite constitutional majority, is therefore adopted. Chair recognizes the senator from the 2nd.
Mr. President, I move that Senate Bill 40 be removed from the table.
Mr. Secretary, can you please read the caption?
Senate Bill 40 by Senator Jackson II and others. A bill to be titled an Act to amend Code Section 1665.1 of the OCGA relating to sexual assault by persons with supervisory disciplinary authority so as to prohibit sexual contact between an employee or volunteer of any school and a student enrolled at such school and for other purposes. Mr. President, on February 27, 2020, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted by Senator Stone, the 23rd chair. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 40. A bill to be titled an Act to amend Chapter 6 of Title 16, Article 1 of Chapter 10 of Title 17, Article 2 of Chapter 3 of Title 35, Title 42, and Article 1 of Chapter 2 of Title 49 of the OCGA relating to sexual offenses, procedure for sentencing, and imposition of punishment, the Georgia Crime Information Center, and for other purposes. That completes the order, Mr. President.
Senator from the 2nd has asked that Senate Bill 40 be taken off the table. Is there objection? The chair hears none, and Senate Bill 40 is taken off the table. The chair recognizes the senator from the 2nd to speak to the bill.
Thank you, Mr. President. Members, Senate Bill 40 is a very simple bill. It revised code sections for the crime of improper sexual conduct by an employee or an agent. Provide that the offenses of improper sexual conduct by a person in a position of trust, that's a coach or volunteer in the school district, that they be an illegal act. What this bill simply says is that people of trust, coaches or volunteers, should not have sex with students. People of trust should not have sex with students. Mr. President, this is a very simple bill. I urge all you to favor this motion. If there are no questions, Mr. President, I yield the will.
You have no questions. Does any other senator wish to speak for or against Senate Bill 40? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 18th.
Thank you, Mr. President. I would ask that SB 410 be removed from the table.
Mr. Secretary, please read the caption.
Senate Bill number 410 by Senator Kennedy of the 18th and others. The bill to be titled an Act to amend Code Section 485311 of the OCGA relating to creation of county boards of equalization, duties, review of assessments, and appeals so to provide for an alternative means of recovering costs of litigation and attorney's fees and ad valorem tax appeals and for other purposes. Mr. President, on March 2nd, 2020, the Senate Committee on Finance recommends that this bill do pass. Respectfully submitted by Senator Huffstetler, the 52nd chair. That completes the order, Mr. President.
Senator from the 18th has moved that Senate Bill 410 be taken off the table. Is there objection? The chair hears none, and Senate Bill 410 is taken off the table. The chair recognizes the senator from the 18th to speak to the bill.
Thank you, Mr. President. I bring you colleagues Senate Bill 410 that seeks to really close a small loophole that works really in a bad way for taxpayers and property owners who file an appeal for their property tax assessment. The way it currently works under our rules is that if you appeal the valuation being provided to you on your property, you can, if you want to appeal that assessment, you do so to the Board of Assessors. If the resulting amount of the valuation is 85% or less of what was assessed of your property, then you have won the appeal, and you also are entitled to receive attorney's fees to be paid by the county. So what happens if you win there, but then the county files an appeal of that to the next level, which is the Superior Court? If you then go to the Superior Court and you win, and that valuation is sustained so that it's less than 85% of the assessed value, you've won the assessment, but at that level, you cannot get attorney's fees. And so what we're finding is that counties, knowing that they have improperly overly assessed your property, will appeal to the Superior Court just for the purpose of denying you the ability to get attorney's fees recovered, even though you win the assessment battle. This seeks to close that loophole so that it becomes consistent. If you win at the first level, you get your attorney's fees. If you go to the second level and you win, you get your attorney's fees there. That's all the bill does. I'm happy to answer any questions, Mr. President.
Chair recognizes the senator from the 6th for a question.
Will the senator yield?
I will.
Does this apply to commercial tax appeals as well? Or you indicated residential?
Yeah, excuse me, if I said residential, I believe it applies across the board for anyone who appeals a property valuation.
So with respect to that, in terms of residential property appeals, do you know on average how many actually go to the Superior Court?
No, and I don't know the average number, and I don't know that there's an average. It probably might vary from county to county. It might vary from different areas of the state where property values are being reassessed versus where it's not.
And would the senator yield?
Sure, be happy to.
Isn't it true, Senator, that most appeals to the Superior Court are done by commercial property owners who hire big-time attorneys and big-time law firms and incur thousands and thousands of dollars worth of attorney's fees that then the counties will be on the hook for with respect to any appeal of their commercial valuation?
No, Senator, I would not agree with that. I don't think there's any empirical evidence to suggest that it's only commercials that do that. And even if it is more commercial than residential, it sidesteps the issue that if you have had your property inappropriately assessed too high and you win the appeal, you should be able to recover your attorney's fees for having endured that fight and won it.
Senator, you have no more questions.
Thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against Senate Bill 410? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none and the main question is ordered. The questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 18th.
Thank you, Mr. President. I would ask that SB 411 be removed from the table.
Mr. Secretary, please read the caption.
Senate Bill number 411 by Senator Kennedy of the 18th and others. A bill to be titled an act to amend Part 2 of Article 4 of Chapter 3 of Title 46 of the OCGA relating to corporate purposes and powers of electric membership corporations, so as to require electric membership corporations to comply with certain requirements in determining the rates for attachments to utility poles by communication service providers and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass by substitute. Respectfully submitted by Senator Cowsert of the Chair. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following substitute to Senate Bill 411. A bill to be titled an act to amend Part 2 of Article 4 of Chapter 3 of Title 46 of the OCGA relating to corporate purposes and powers of electric membership corporations and for other purposes. Mr. President, Senator Kennedy of the 18th and others offer the following amendment number 1 to amend the Senate Committee on Regulated Industries and Utilities substitute to Senate Bill 411 by inserting between 2020 and the period on line 29 the following: to which a certificate of authority has been issued pursuant to Code Section 465163. That completes the order, Mr. President.
Senator from the 18th has moved that Senate Bill 411 be taken off the table. Is there objection? There is objection. All those in favor of removing Senate Bill 411 from the table will vote yea. Opposed, nay. The Secretary will unlock the machine. Chair recognizes Senator from the 45th.
Parliamentary inquiry.
State your inquiry.
Is it not true they have been negotiating out in the hall on this particular Bill 411 and it's not worked out? And there are people in this room who don't feel comfortable. Is that not true?
The chair's not privy to that conversation. On the motion to remove from the table, the yeas are 26, the nays are 27. The motion has lost, and Senate Bill 411 is not removed from the table. For what purpose does the Senator from the 18th rise?
Motion to reconsider the motion to pull from the table. Senate Bill 411, please.
The Secretary has informed me that you cannot reconsider it, but you can move it at a later point. For what purpose does the Senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that there is a lot of dissension and questions about this particular bill, and if it comes off the table, then it potentially could take a very long time to resolve it and come to a vote? Is that not true?
Each and every member will have to come to that decision. Chair recognizes the Senator from the 53rd.
Thank you, Mr. President. I move to remove Senate Bill 375 off the table.
Mr. Secretary, please read the caption. Okay, I'll get.
Senate Bill number 375 by Senator Mullis of the 53rd and others. A bill to be titled an act to amend Article 7 of Chapter 12 of Title 16 of the OCGA relating to sale or distribution to or possession by minors of cigarettes and tobacco-related products, so to provide for additional penalties regarding any person under 21 years of age and vapor products and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass by substitute. Respectfully submitted by Senator Cowsert, Chair. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following substitute to Senate Bill 375. The bill to be titled an act to amend Title 16 of the OCGA relating to crimes and offenses so as to increase the age of individuals to which the sale or distribution of cigarettes, tobacco products, and for other purposes. That please. Mr. President, Senator Unterman and Senator Mullis offer the following amendment To amend the Senate Committee on Regulated Industries and Utilities substitute to Senate Bill 375 by inserting between forfeiture and to provide on line 6 the following. To amend Title 20 of the OCGA relating to education so as to require local boards of education to prescribe mandatory instruction and a minimum course of study concerning the dangers of smoking and vaping. That please order, Mr. President.
Senator from the 53rd has asked that Senate Bill 375 be taken off the table. Is there objection? The chair hears none, and Senate Bill 375 is taken off the table. The chair recognizes the senator from the 53rd to speak to the measure.
Thank you, Mr. President. Another great day for a great bill. This is Senate Bill 375 is dealing with vaping on school property. So as the senator from the 46th would say, looky here. This would disallow vaping and vaping products to be sold or obtained on school property by everybody. It says 21 for those minors, and when I say minor, Senator from the 7th is confused. I don't mean like a gold mine or a salt mine or a coal mine. I'm talking about young people. And since the federal government's moved the age to 21, we're talking about 21 and lower. So this would disallow vaping on school property by adults and by children. If it is discovered, law enforcement or school officers would be allowed to obtain the vaping devices and destroy them eventually. So we're trying to keep vaping out of hands. Now, vaping, I think, and the senator from the 45th would know better because of her medical experience, but it was created to keep for those who are those adults who are smoking and trying to find an easier way out of smoking. And some may talk about Nicorette because it was created for the same thing, to take the pleasure of smoking, since it's harmful to you, and make it so you can get out of that terrible desire. So vaping was done for that reason too, but not for minors to use. This is to keep it off school property. I'd like to thank the Regulated Industries Committee under the senator from the 46th leadership, as well as senator from the 44th, to help on this issue. And also this came from me from original high school school officer, Bruce Coker, who actually ran against me many years ago, but he and I are dear friends now. He brought this to me and said it's a major problem. So we have worked to disallow and to eliminate that major problem on high schools property. Senator from the 45th and myself has come together on an amendment to improve the bill, and she will tell you all about that. I'd be honored to answer any questions, or I would make my way out of the well, if need be.
Praise the Lord.
Are you up there now? Please help me, Lord. Are there any questions, Mr. President?
Senator, you have one question.
Okay.
Senator from 33rd, recognized for a question.
Yes, sir, Doc.
Thank you, Mr. President. Does the senator yield?
I do for you, absolutely. Man from Cobb County, I'll quit.
The Crown Jewel Colony. Looky here, Senator. Can I assume the way you sprinted up to the well that you don't use tobacco or vaping products and you're just a tad bit over the age 21?
Yeah. You're so kind, Senator from Cobb County. And I have never used that product, actually. I'm not going to talk about related products, but never that one. And what are y'all talking about? And vaping is a bad thing. Used to take you 50, 60 years to die from tobacco, and that could be overnight. So I appreciate your favorable experience on a great vote on this bill. Mr. President, I yield the well.
The senator has yielded the wells. Recognize the senator from the 45th to speak to her amendment.
Thank you, Mr. President. I bring before you an amendment to the substitute to Senate Bill 375. And the Rules Chairman is exactly right that vaping is at epidemic proportions. And when we had our hearings in the chairman of the 46th Senate District, we learned that the epidemic is not just with high school students, but more so even with middle school students. And the chairman's exactly right that this epidemic, that smoking one time and not knowing the substance that could be shipped in from China or from Mexico could be potentially lethal. And we have had specific instances in Georgia of students who have vaped and who have lost either their lung capacity or been on ventilators, been in intensive care units, and their lungs are damaged for the rest of their lives. So with Amendment Number 1, it is a component of another vaping bill, and it adds back into the substitute to Senate Bill 375 the word vaping, where you have cigarettes and smoking. Vaping is a new terminology that is not in the Georgia Code. It adds that. It also requires that vaping be included along with alcohol and drug abuse education that is required and mandated in the state of Georgia, that vaping be included with it. That line is on, those lines are on line 50 through 52. I'll be glad to answer any questions. I ask for your favorable consideration of Amendment Number 1. No further questions. I yield the well.
Does any other senator wish to speak for or against the measure? The chair hears none. The senator. On the adoption of Amendment Number 1, is there objection? Hearing no objection, the amendment is adopted. The question on adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is now ordered. The question on the passage of the bill by substitute. All those in favor vote yea. Those opposed vote nay. Mr. Secretary, if you'll unlock the machines. On the passage of the bills, the yeas are 52 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Call upon the senator from the 46th. Oh, stand by, Senator. You had to move. Take it off the table.
Thank you, Mr. President. I move that Senate Bill 428 be removed from the table.
Is there objection? Mr. Secretary, would you read the caption?
428 by Senator Cowsert of the 46th and others. Bill to be titled an act to amend Part 2 of Article 15 of Chapter 1 of Title 10 of the OCGA relating to the Fair Business Practices Act of 1975, so to prohibit the deceptive practice of musical performance groups advertising and appearing as the recording group without the recording group's permission or denoting that it is a salute or tribute performance and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted by Senator Cowsert of the 46th Chair. That completes order, Mr. President.
Motion to take off the table. Is there objection? Hearing none, Senator from the 46th is recognized to speak to the bill.
Thank you, Mr. President. Ladies and gentlemen, this is a bill to protect the musical rights of groups that have performances and recordings, and folks are basically knocking them off. It amends the Fair Business Practices Act to make it illegal to unfairly advertise or conduct performances with misleading, false, or deceptive advertising, essentially presenting yourself as another group when you don't have the right to do so. There are exceptions if you do own the recording rights or the publishing rights to the music, or if you have a member, at least one member of your band that does have the right to use that name, or if you're a tribute band and you're making it clear in your advertising that you are not the original group, you're simply playing the music of the original group. This is a very simple bill, just gives some teeth to people that own recording rights to prevent others from infringing on their rights. I'm willing to answer any questions. Otherwise, I urge your favorable consideration, and I will yield the well.
You have no questions, Senator.
Thank you, Mr. President.
Does any other senator wish to speak for or against the measure? Hearing none, is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being in order? The chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. The nay vote. Those opposed vote nay. Mr. Secretary, unlock machine. On the passage of the bill, the yeas are 48 and the nays are 0. This bill has passed. Call upon the senator from the 14th.
Thank you, Mr. President. I move that we remove SB 428 from the table.
Mr. Secretary, if you read the caption. 493.
I stand corrected, 493.
Senate Bill number 493 by Senator Thompson, the 14th, and others. A bill to be titled An Act to amend Chapter 1 of Title 10 of the OCGA relating to selling and other trade practices so as to provide for legislative findings, provide for standards of cybersecurity programs to protect businesses from liability, provide for affirmative defenses for data breaches of private information and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Veterans, Military, and Homeland Security recommends that this bill do pass. Respectfully submitted by Senator Thompson, Chair. Back, please, order, Mr. President.
Is there objection? Call upon the senator from the 14th to speak to the bill.
Thank you, Mr. President. We live in different times with cyber attacks happening every day to our businesses. And what this seeks to do is create safe harbor. It's just a framework, voluntary framework, that in the event that a business is hacked or there's a vulnerability breach, it provides a defense mechanism should they wind up in court. And with that, Mr. President, I'll yield the well.
Does any other? The senator has yielded the well. Is there any other senator who wish to speak for or against the measure? Hearing none, Is there objection to the agreeing of the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. All those opposed vote nay. Mr. Secretary, if you'll unlock the machines. Senator from the 14th, that was eloquent and direct and to the point. Thank you, sir. On the passage of the bill, the yeas are 30 and the nays are 18. This bill, having received the requisite constitutional majority, is therefore passed. Call upon the senator from the 52nd.
Mr. President, I ask that Senate Bill 480 be removed from the table.
Mr. Secretary, if you'd read the caption.
Senate Bill number 480 by Senator Huffstetler of the 52nd. A bill to be titled An Act to Amend Article 1 of Chapter 2 of Title 48 of the OCGA relating to state administrative organizations so as to authorize compensation to be paid from sales and use tax collections on a contingency basis with respect to services that assist the Department of Revenue in the identification of taxpayers that are non-compliant with sales and use taxes and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Finance recommends that this bill do pass. Respectfully submitted by Senator Huffstetler of 52nd. Chair. That completes the order, Mr. President.
Is there objection to removing Senate Bill 480 from the table? Hearing none, the senator from the 52nd is recognized to speak to the bill.
Thank you, Mr. President. I was talking just a few days ago about my late friend, Chairman Jay Powell of the House, and one of the bills he had from 2018 that was to go in effect on October 1st of 2018 was to use artificial intelligence through a proprietary algorithm to collect revenue in the state of Georgia from people that weren't paying what was due. He, as well as I, believe that there's hundreds of millions of dollars there that could be collected in revenue that is owed to the state. It's been a little bit slow starting out from the Department of Revenue. However, they did tell me yesterday they've signed contracts for 2 test markets and working with a third company to do that. They had said several months ago that they didn't think they had a mechanism to pay them. This is at no cost to the state. It's just simply on a fee basis for money that's brought in, and they didn't have a way to pay them. So this bill's an attempt to make sure that they've got a method of payment for these contracts when they go into effect. If there's no questions, I'll yield the well.
Senator, you have no questions. Does any other senator wish to speak for or against the measure? Hearing none, is there objection to agreeing to the report of the committee substitute favorable to the bill? The chair hears none. The report of the committee substitute is agreed to. Is there objection to the main question being ordered? The chair hears none. The question is ordered. The question on the passage of the bill. All those in favor vote yea. Opposed vote nay. Mr. Secretary, if you unlock machines. Ladies and gentlemen, if there's someone with a recording or a video running, On the passage of the bill, the yeas are 50, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the Gold City. How you doing?
Thank you, Mr. President. Not paying attention here. I'd like to ask that we remove SB 489 off the table.
Mr. Secretary, if you'd read caption.
Senate Bill number 489 by Senator Gooch of the 51st and others. A bill to be titled an Act to Amend Part 2 of Article 1 of Chapter 8 of Title 40 of the OCGA relating to lighting equipment of motor vehicles so as to repeal provisions requiring an amber strobe light upon low-speed vehicles and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Transportation recommends that this bill do pass. Respectfully submitted by Senator Beach of the 21st Chair. That please order, Mr. President.
Is there objection to removing Senate Bill 489 from the table? Hearing none, recognize Senator from the 51st speak to the measure.
Thank you, Mr. President. Senators, this is a real easy bill. All this bill does is repeals a requirement that we put on slow-moving vehicles some years ago that allow electric cars in 35-mile-per-hour speed zones in cities to require them to have a strobe light on top of the vehicle. That requirement is no longer needed. This will allow other competitors from across the country to come to Georgia with the autonomous vehicles. I'll take any questions or I'll yield for your support.
Senator, you have no questions. Is there any other senator wish to speak for or against the measure? Chair hears none. Is there objection to agreeing the report of the committee is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The question is now ordered. The question is on the passage of the bill. Those in favor vote yea. Those opposed vote nay. Mr. Secretary, if you unlock the machines. On the passage of the bills, the yeas are 46 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Call upon the senator from the 43rd.
Thank you, Mr. Speaker. I ask that Senate Bill 288 be removed from the table.
Mr. Secretary, if you'd read the caption.
Senate Bill 288 by Senator Anderson of the 43rd and others. A bill to be titled an Act to Amend Code Section 35.337 of the OCGA relating to the review of individuals' criminal history record, information, definitions, privacy considerations, written application requesting review and inspection, so as to provide for the automatic restriction of certain criminal history record information of arrests when there has been a final disposition and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted by Senator Stone of the 23rd Chair. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 288, a bill to be titled an Act to Amend Article 2 of Chapter 3 of Title 35 of the OCGA relating to the Georgia Crime Information Center so as to expand the ability of certain individuals to request record restriction for certain misdemeanor and conditional discharges and for other purposes. Mr. President, Senator Anderson of the 43rd and Senator Payne of the 54th offer the following amendment number 1 to amend the Senate Committee on Judiciary substitute to Senate Bill 288 by inserting after restriction on line 251 under the subsection and by inserting the following after line 301. 6, when an individual was convicted in the state of an offense for which that individual has been granted a pardon from the State Board of Pardons and Paroles and for other purposes. That please order, Mr. President.
Is there objection for removing the bill? Call upon the senator from the 43rd to speak the measure.
Thank you, Mr. President. Senate Bill 288 does two things. One, it allows for rehabilitated individuals the ability to petition the courts to have certain misdemeanor convictions restricted and sealed so that they have the opportunity to get a job and have access to housing. It also, number two, protects employers and encourages them to hire rehabilitated individuals. Georgia is behind the rest of the nation on this matter. 41 states allow a rehabilitated individual the opportunity to restrict and seal some convictions after a period of time. Over 40% of all Georgians have a criminal history, and over 10% of all Georgians have a criminal history with one misdemeanor conviction. In other words, out of 11 million Georgians, 4.2 million Georgians have some type of record. If an individual has served their full sentence and remained crime-free for 4 additional years, this bill would allow them to petition the courts to restrict and seal their records. Serious violent crimes and sexual crimes are a list of misdemeanors that cannot be restricted. Prosecutors and judges would have to sign off on every restriction or sealing. Employers are supportive of this effort. You will see a letter on your desk from the Atlanta Metro Chamber in support of this measure. Over the last 10 years, Georgia's employment growth has outpaced the nation, but our state labor force growth has not and was flat last year. Currently, there are hundreds of thousands of open jobs in Georgia, all while the unemployment rate for individuals with a record is about 15%. Having a job is the number one way of allowing people to take care of their families and the number one way of preventing recidivism. If you have served your full sentence for a misdemeanor and proved that you have been rehabilitated, you deserve the ability to get a job. It makes communities safer and strengthens our economy. This bill also protects employers that hire rehabilitated individuals by prohibiting the admission of a criminal history record if the record is restricted. The amendment provides for an individual who is convicted and has been granted a pardon from the State Board of Pardons and Paroles as provided in the code section 42-9-42, as long as the offense was not a serious violent felony or a sexual offense. The individual has not further been convicted of any other crime. With that, Mr. Speaker, I will take I'm sorry, Mr. President. I'm sorry, Mr. President.
I do not resemble that remark.
I will yield to questions.
Senator from the 23rd, you're recognized for a question.
Thank you, Mr. President. Will the senator yield?
Yes, I will.
Isn't it true that this is a great bill, that it extends the process that had only been available for youthful offenders to those convicted of misdemeanors?
Yes, it is.
And isn't it true that the amendment only extends it just one step further to those in front of the pardon who receive a pardon?
Yes, it does.
And it carves out violent felonies and sexual crimes?
It does. Those are not included.
And isn't it true I support the amendment too?
Yes, it is true, Mr. Chairman, and I appreciate your support.
Good bill.
Thank you so much.
Call upon the senator from the 27th for a question.
Thank you, Mr. President. Does the representative yield?
No, I do not.
Touche.
Does the senator yield?
Yes, I do.
Thank you. I do have a serious question, and I don't want to read these lines out loud just because it's a little uncomfortable, but I'm curious why we are striking lines 268 through 270 from the list of things that can be restricted from a record. They basically reference sexual activity for hire as far as I read 268 and potentially 269 as well.
Thank you for the question. Actually, it was actually a cleanup for the code, the current code. And I know the list sounds and probably looks a little dirty, but it was just a code cleanup.
Okay, thank you.
You're welcome.
You have no further questions, Senator. Any call upon the 45th.
Oh,
you have no further questions, Senator.
Thank you, Mr. President, the most wonderful president in the world, the entire world. Thank you.
All handsome with a full head of hair. Call upon the Senator from the 45th to speak to the measure.
Thank you, Mr. President. Members of the Senate, I appreciate the Senator bringing forth Senate Bill 288, and I rise in favor of this bill and also in favor of the amendment. And the reason I'm here is because it's kind of sentimental. Y'all know I'm leaving, and kind of words of wisdom that I'm trying to bestow upon you. But for the past couple of years, Gwinnett County was very fortunate to receive the first federal grant about the Georgia Reentry Program. And I just want to encourage you in your individual counties that some of your counties do have these reentry programs set up and moving forward. Some of the counties, because I've talked to some of the senators, do not even have these existing programs. And I want you to encourage with your state government, as federal, state, and local government, to work with your local folks, your local elected representatives, your Board of Commissioners in these reentry programs. I go to the meetings at least quarterly, and I can tell you how fulfilling it is to go to the meetings and to see these different levels of government working with these reentry programs. And they are absolutely phenomenal. And when you go to your local correction facility, and you see the people in that facility going through their programs, it is amazing work that we're doing, and it all started out with former Governor Deal on the reentry program. But I encourage you to ask your Board of Commissioners, why don't you have this program, and why don't you help fund it with the state of Georgia? Because these people get a second opportunity, a second chance. And it is so fulfilling as a state senator to go and see the volume of people that you're helping, and the success rate is phenomenal. So I encourage you to look up the Georgia Reentry Program in your individual county, and I yield the well. Thank you very much.
Thank you, Senator. Senator from the 54th. You're recognized to speak to the measure.
Thank you, Mr. President. Friends, I rise, as many of you know, for 30 years. I had the blessed opportunity to serve as working with youthful offenders as a state juvenile probation officer. And I will tell you that what I loved about my job was seeing the actions of restorative justice in front of me, when you saw not only the victim, but also the assailant restored after a crime had been committed. And truly, in this true sense of the word justice, when we restored as if the crime had never happened. This is just a continuation of that, and I'm wholeheartedly behind this, because right now we have thousands upon thousands of young offenders in our state that they've passed the age of, they're 17 or older, but between that age, psychologists will tell you that the brain's not fully developed until we get into our 20s at some point. And so this allows all those tens of thousands of youthful offenders that have one or two minor misdemeanors to give them a new start. And if for Georgia to continue to be the #1 state to do business, we're in need of new people, talented people
be able to go into advance in the workforce. And this just gives a lot of those people the same opportunity to find restorative justice and to move forward so that they can have meaningful and purpose-filled lives. If there are no questions, Mr. President, I will yield the well.
You do have questions. Senator from the 23rd, you recognized for a question.
Thank you, Mr. President. Will Senator yield?
I do.
All right. The record restriction under this bill does not extend to law enforcement. Is that correct?
That is correct.
Just for members of the private sector.
Right.
Thank you.
Senator from the 45th, you recognized for a question.
Would Senator yield?
Yes, ma'am. I will.
Senator, since you have such vast experience, isn't it true that it's often just one time that juvenile understands and they become shocked that they had done something wrong, that if you give them that second opportunity, they never repeat it again? Is that not true?
That is true, and I will tell you, as a probation officer, I would tell my 16-year-old sitting in front of me in my office, I said, one day you're going to wake up in your 20s, and just like all of us, everyone in this room did. We wake up in our 20s one day and we think, my God, my parents were the smartest people on the face of the earth. We didn't think that way at 16. We didn't think that way at 16. We all thought we had it figured out at 16, and it's literally, we make poor judgments and poor decision making during those years, and this just gives them an opportunity to restore that.
Senator, you have no further questions.
I will yield the well and ask for your favorable support. Thank you.
Does any senator wish to speak for or against the measure? Hearing none. The question is on the adoption of amendment number 1. Is there objection? Hearing no objection, the amendment is adopted. The question is on adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question now being ordered? Chair hears none. The main question is ordered. The question on the passage of the bill by substitute. Are all those in favor vote yea? Those opposed vote nay. Mr. Secretary, unlock machines. This is definitely much more time consuming when you take this off the table. Wouldn't you say? This is definitely more time consuming when you're taking them off the table. Let's slow it down. We are at 818, is that where we are? 818, 818, yeah, okay, thanks. On the passage of the bill, the yeas are 49, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Congratulations, Senator from the 43rd. Senator from the 27th, you are recognized.
Thank you, Mr. President. I move that we remove Senate Resolution 818 from the table.
Mr. Secretary, if you read the caption.
Senate Resolution 818 by Senator Dolezal of the 27th and others. Resolution proposing an amendment to the Constitution of the State of Georgia so as to clarify that only citizens of the United States shall have a right to vote in elections in this state. Provide for related matters, provide for the submission of this amendment for ratification or rejection, and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Government Oversight recommends that this bill do pass. Respectfully submitted by Senator Heath of the 31st Chair. That completes the order, Mr. President.
Is there objection to taking Senate Resolution 818 off the table? There is objection. All those opposed all those in favor of taking 818 off the table, stand and rise. All those in favor of taking 818 off the table, stand and rise. All those in favor of taking 818 off the table, stand and rise. Raise your hand. Raise your hand. Raise your hand. Reverse. Reverse. Those opposed, reverse. There's a motion for yeas and nays. We're trying to hear all the bills. We need 5. There are clearly 5. All those in favor vote the yay switch. All those in favor of taking this bill off the table vote the yay switch. All those in favor, take it, Mr. Secretary, if you'll allow the machines. Senator from 31st, why do you rise?
Mr. President, isn't it true that this bill passed out of committee unanimously in bipartisan fashion?
I'm sure the senator knows of what he speaks. Trying to save y'all a few minutes there, sorry. That was my position. I was overruled by the secretary. I was overruled by my lawyer. On the measure, the yeas are 30 and the nays are 17. This measure will be taken off the table. Recognize the senator from the 27th.
Thank you, Mr. President and colleagues. This constitutional amendment is quite simple in concept, and it simply enshrines in the Constitution the exclusivity of the right to vote in our elections to citizens of the United States of America. Currently, our Constitution recognizes that everyone who is a United States citizen may vote in our elections. The exclusivity to only being a United States citizen is merely in the statute of the law, specifically Title 21, Chapter 2, Article 6. And this constitutional amendment would raise the bar and enshrine in the Constitution the exclusivity and the instruction that only United States citizens shall vote in our elections. Mr. President, with that, I'd be happy to answer any questions, and if not, I'd yield the will.
You do have questions. Question, Senator from the 41st, you're recognized for a question. He waves off. Senator from the 42nd.
Thank you, Mr. President. Will the gentleman yield?
Absolutely.
I am looking for the bill. I apologize, since we're out of order.
818.
I know. I can't find it. Yep, thank you. I'm confused. It appears that what you're trying to do is already in the law.
Well,
I don't really understand the
if I had a
constitutional
rule
amendment.
if I had a rule that said every senator was allowed to be on this floor, that rule would also allow staff to be on the floor. If I had a rule that stated that only senators were to be allowed on this floor, that would exclude staff from being on the floor. Similarly, the current Constitution, I should say, states that every person who is a citizen, that is not instructive, it is inclusive to citizens. We're changing the inclusive language to instructive language to very clearly state that only individuals who are citizens of this country can vote in elections in this state.
Senator, has this been an issue? Because I haven't heard of this issue, and it appears to me, as I already said, that it's fairly clear that what you're saying you want to do is already the law.
What we're saying, you're correct that it is already the law. We are moving it up to what I believe is the appropriate place for it, which would be in the Constitution of the state.
Thank you.
You have no further questions, Senator. Senator from the 41st, you recognize.
Mr. President, members of the Senate, there's little more important than amending our state constitution. It's a very important act. Presently, the law reads, very clearly that voting is a right of a citizen. The state constitution was originally amended in 1877 for citizenships to vote. State law separate to the Constitution also states that you have to be a citizen of Georgia to vote. So we ask ourselves, why are we here? Why are you making a little semantic change to the wording? And the reason is politics. We all support state law about citizen voting. This is on our desk and is intended to be on the ballot for political reasons, to try to mislead people and to deceive people that this is needed to keep non-citizens from voting. That is not the case. I am not in favor of amending our state constitution and so a super PAC can raise money to spend to try to turn out a vote for partisan political reasons and not a constructive reason. I think that's wrong. So very simply, the President of the Senate, or pro tem, recently said we shouldn't be wasting time for ayes and nays. More importantly, we shouldn't be wasting time and money amending the Constitution on something that has no constructive effect, on something that state law already covers, and something our state constitution already addresses. So I would like you to please vote down this Constitution. Let's move on with the business of this state and stop wasting our time on politics and not plans to move Georgia forward. I yield the well. There's questions.
No questions, Senator. Does any other senator wish to speak for or against the measure? Hearing none, is there objection to the agreeing of the report of the committee favorable to the adoption of the resolution? The chair hears none. The committee's report is agreed to. Is there objection to the main question now being ordered? The chair hears none. The main question is ordered. The question is on the adoption of the resolution. All those in favor vote yea. Those opposed vote nay. Mr. Secretary, if you unlock machines. Why do you rise, Senator from the 53rd? Just to say hello? Thank you. This measure required 38 votes. There are 33 yeas and 19 nays. This measure, not having reached the requisite constitutional majority, two-thirds majority, has therefore lost. Is it going to call? Move to recon. Senator from the 32nd, you are called upon.
Thank you, Mr. President. I move that Senate Bill 477 be removed from the table.
Mr. Secretary, if you'd read the caption.
Senate Bill number 477 by Senator Kirkpatrick of the 32nd and others. A bill to be titled an act to amend Code Section 17.420.1 of the OCGA relating to investigation of family violence, preparation of written report, review of report by defendant arrested for family violence, and compilation of statistics, so as to revise the terminology used when determining whom to arrest and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Judiciary recommends that this bill do pass by substitute, respectively submitted by Senator Stone, the 23rd chair. Mr. President, the Senate Committee on Judiciary offers the following substitute Senate Bill 477, a bill to be titled an act to amend Code Section 17-420.1 of the OCGA relating to investigation of family violence, preparation of written report, review of report by defendant, rest of her family violence, and for other purposes. That completes order, Mr. President.
Is there objection for moving Senate Bill 477 from the table? Hearing none, Senator from 32nd, you are recognized to speak to the measure.
Thank you, Mr. President. Senate Bill 477 has to do with family violence investigations. Family violence investigations by law enforcement can sometimes result in the unintended arrest of a victim. This bill defines the term predominant aggressor and makes it clear that the person who represents the most serious threat is the one to be arrested. This bill is supported by the Commission on Family Violence, of which I am a member, as well as law enforcement and the Prosecuting Attorney's Council. It should make it easier for law enforcement to train their officers in domestic situations. I'd be happy to answer any questions.
You have no questions, Senator.
Thank you. I yield the well.
Does any other senator wish to speak for or against the measure? Hearing none. The question is on adoption of a committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to hearing the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question now being ordered? The chair hears none. The question is agreed to. The question on the passage of the bill by substitute. All those in favor vote yea. All those opposed, nay. Mr. Secretary, if you'll unlock the machine. The yeas are 50, the nays are 0. This bill, receiving the requisite constitutional majority, is therefore passed. Secretary, the senator from the 29th, you are recognized.
Mr. President, I move that Senate Bill 412 be removed from the table.
Mr. Secretary, if you'd read the caption.
Senate Bill 412 by Senator Robertson of the 29th and others. A bill to be titled an act to amend Code Section 3376 of the OCGA relating to property insurance, contract requirements, rules and regulations, and exemptions, so as to revise the meaning of property insurance, to change the parameters under which certain contracts, agreements, or instruments may be canceled and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Insurance and Labor recommends that this bill do pass by substitute, which was submitted by Senator Martin of the 9th. Mr. President, the Senate Committee on Insurance and Labor offers following a substitute to Senate Bill 412, a bill to be titled an act to amend Code Section 3376 of the OCGA relating to property insurance, contract requirements, rules and regulations, exemptions, so as to revise the meaning of property insurance, to change the parameters under which certain contracts, agreements, or instruments may be canceled and for other purposes. That completes order, Mr. President.
Is there objection to removing Senate Bill 412 from the table? Hearing none, Senator from the 29th recognized to speak to the measure.
Thank you, Mr. President. Colleagues, Senate Bill 412 revises existing laws applicable to service contracts to make the laws here in Georgia more consistent with the regulatory treatment of these service contracts, sometimes called extended warranties. These are optional agreements which a consumer may choose to purchase to provide coverage for the repair of certain damages to vehicles or the replacement of certain items such as key fobs and other things associated with a vehicle. This legislation benefits both Georgia businesses and consumers and has been negotiated with the Department of Insurance, and they are in support of this legislation. This legislation also aligns cancellation requirements that if someone attempts to use a service contract only temporary in order to get a pre-existing condition repaired on a vehicle and then cancel the policy, is when they file for the cancellation, any monies that have been spent to solve the problem are then deducted from their normal refund that they get for canceling the policy. It also requires that service contract companies provide full disclosure and a refund within 45 days of the request of any consumer that purchases one of these contracts. It's a good piece of legislation for business and a good piece of legislation for consumers. Mr. President, if I have no questions, I yield the well.
No questions, Senator. Does any other senator wish to speak for or against the measure? The senator from the 10th. Did you want?
I want to make a motion, Mr. President.
State your motion.
I want to be excused from voting based on Rule 5-1.8D on this, on SB 412.
Yes. Without objection, the senator is excused. Does any other senator wish to speak for or against the measure? Hearing none. The question is on the adoption of a committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee that is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question now being ordered? The chair hears none. The main question is now ordered. Question on the passage of the bill by substitute. All those in favor, vote yea. Those opposed, vote nay. Mr. Secretary, if you'll unlock the machines. The yeas are 47 and the nays are 1. This bill, having received a constitutional majority, is therefore passed. While we're on a quick break here, I would like for our Senate colleagues to welcome not the First Lady, but the Second Lady from the 9th, the lovely Charlotte Martin. Glad to have you here today, Charlotte. Senator from the 29th, you're recognized once again.
Mr. President, I move that Senate Bill 272 be removed from the table.
Secretary, if you'll read the caption.
Senate Bill number 272 by Senator Robertson of the 29th. A bill to be titled an act to amend Part 1 of Article 2 of Chapter 13 of Title 16 of the Official Code of Georgia annotated, relating to schedules, offenses, and penalties regarding the regulation of controlled substances so as to prohibit the sale to and by minors of the drug products containing dextromethorphan and for other purposes. Mr. President, on February 18th, 2020, the Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted by Senator Watson, the first chair. Back, please, order, Mr. President.
Is there objection for removing Senate Bill 272 from the table? Hearing none, recognize the Senator from the 29th. Speak to the measure.
Thank you, Mr. President. Senators, I think we heard from the well earlier about the development of the human brain and how, as teenagers, it takes a while for us to understand the damage we can cause by poor decisions. Throughout my career in law enforcement, I saw a lot of young people take very risky chances using substances that they thought were safe, but if they used it in an unsafe manner, that they received some type of dopamine dump or adrenaline dump that they would find pleasure from. This led to all kind of problems. In 2000, a 2008 study found that 1 in 10 American teens has abused products containing dextromethorphan in order to get high, making it more popular than cocaine, ecstasy, crystal meth, and LSD. What this legislation does, it requires proper identification, meaning a document issued by any government agency containing a description of the person, a person's photograph or both, and given the person's date of birth. What it does is it defines a minor as anyone under the age of 18 years, and this product to be purchased in a store, any of the cough medicines or other products that contain this substance would require an individual to show a driver's license to prove that they are 18 and older, therefore preventing as much abuse by young people as possible with this substance. If there are any questions, Mr. President, that's it, and I'll answer any questions.
Senator, you have no questions.
Thank you. I yield the way.
Does any other senator wish to speak for or against the measure? Hearing none. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee substitute is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is now ordered. The question is on the passage of the bill. All those in favor vote yea. Those opposed vote nay. Mr. Secretary, if you unlock the machines. Senator from the 9th, shouldn't let anyone else vote your machine. Just testing it, huh? On the passage of the bill, the yeas are 44, the nays are 7. This bill, having received the requisite constitutional majority, is therefore passed. Senator from the 14th is recognized.
Thank you, Mr. President. I ask unanimous consent to remove SB 418 from the table.
Mr. Secretary, if you read the caption.
Senate Bill number 418 by Senator Thompson, the 14th, and others. Bill to be titled An Act to Amend Part 1 of Article 5 of Chapter 9 of Title 45 of the OCGA relating to the Georgia State Indemnification Fund, so as to revise when indemnification shall be paid in instances of a heart attack, stroke, or vascular rupture suffered by a public safety officer resulting in certain disabilities or death, and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted by Senator Albers, Chair. Mr. President, the Senate Public Safety Committee offers the following substitute to Senate Bill 418. A bill to be titled An Act to Amend Part 1 of Article 5, Chapter 9 of Title 45 of the OCGA relating to the Georgia State Indemnification Fund and for other purposes. That completes order, Mr. President.
Is there objection to removing Senate Bill 418 from the table? Hearing none, recognize the Senator from the 14th.
Thank you, Mr. President. Members of the Senate, this is a real straightforward bill. SB 418, Georgia State Indemnification Program, simply adds heart attack, stroke, vascular rupture suffered by a public safety officer or another circumstance that would qualify a public safety officer for indemnification payment. If there are no questions, I'll yield the well, Mr. President.
You have no questions, Senator. Does any other senator wish to speak for or against the measure? Hearing none. Hearing none. The questions on adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is therefore adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee substitute agreed to. Is there objection to the main question now being ordered? The chair hears none. The question is now ordered. The question on the passage of the bill by substitute. All those in favor vote nay. All those opposed vote yea. Mr. Secretary, if you unlock the machines. John, you were the only one that caught that. John Albers was the only one listening. Senator from the 9th, why do you rise?
Re-inquiry.
State your inquiry.
Should we as senators and refrain from using the names of other senators while in the chamber?
That is true. Thank you, Mr. Senator, for pointing that out. PK. The yeas are 51 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Sorry. Senator from the 16th, you are recognized. Senator from the 16th. Senator from the 16th. Come in, Tokyo. Senator from the 16th. Earth to Marty. Earth to Marty. I violated Senate rule. I beg your pardon. I will not do that again. I stand corrected. Senator from the 16th, why do you rise?
Yes, I would like to pull Senate Bill 432 off the table.
Mr. Secretary, if you would read the caption. That's funny.
Senate Bill number 432 by Senator Harbin of the 16th and others. A bill to be titled an act to amend Chapter 25 of Title 33 of the OCGA relating to life insurance so as to require annual notification to policy owners and requested beneficiaries of the existence of such policies, to require insurers to review the National Association of Insurance Commissioners' life insurance policy locator on a quarterly basis and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Insurance and Labor recommends that this bill do pass by substitute, submitted by Senator Martin of the 9th. Mr. President, the Senate Committee on Insurance and Labor offer the following substitute to Senate Bill 432. A bill titled an act to amend Chapter 25 of Title 33 of the OCGA relating to life insurance so as to require annual insurer notification to policy owners and requested beneficiaries of the existence of such policies, to require insurers to review the National Association of Insurance Commissioners' life insurance policy and for other purposes. Mr. President, that completes the order.
Is there objection for pulling Senate Bill 432 from the table? Hearing none, the senator from the 16th is recognized to speak to the measure.
Thank you, Mr. President. Got the real one. Yes, this bill is an interesting bill that came to my attention through a constituent, and it has to do with paid-up life insurance policies of some you may even have. This was on a person who was 66 years old. When she was 10 years old, her father bought the policy, and it was a 20-pay life insurance policy. So when she was 30, it was paid up. There is no requirement for notification annually on that policy. She was 66, and her father had been dead for 10 years. Going through his paperwork, she found a policy. That policy was worth over $6,000 to her, and she never knew it existed without going through that. So what the first part of the bill does, it deals with an annual notification to a client, to an insured, that there's a policy in effect and what the benefits are of that portion. The second part has to do with a policy locator. And what you may not know is this, is that how do you find a life insurance policy? Life insurance policies have to be claimed by the beneficiary, and many times they do not know where the policies are. The National Association of Insurance Commissioners 3 years ago created a website that is a national website that you can log on going through the Georgia Insurance Department's website. That website locks you in and takes you to the national website, of which you can put in a request for to see whether there is a policy in existence on the person you're hunting it for. The problem is it's a voluntary system. No one requires it. And what this would do, it requires each and every insurance company to review that website on a quarterly basis and on an annual basis to give a report back to the insurance commissioner. In 2016, this issue was brought up in Florida. There was a $7.5 billion settlement in Florida in reference to lost policies, because the insurance companies know when people have died because they compare their policy listings to the Social Security death benefit list. But until the beneficiary files the claim, the company sits on the money. Now, if they know he's dead, here's the other part they can do with no beneficiary. They will actually send the money to the unclaimed property of the state of Georgia, and that's where the money will ultimately end up if they check. That's the issue. So those two things, I believe, do this. It causes the citizen, helps the citizens of Georgia to find policies they can't find. And number one, for policies that paid up, it requires a annual notification to be done. Mr. President, unless there are questions.
You have a question. The chair recognizes the senator from the 27th.
Thank you, Mr. President. Senator Yield.
I yield.
I'm a little confused, and I want to make sure I follow. So can you outline again for me what the requirement would be for the insurance? They would need to check with the national database and report it to the insurance commissioner, and then what happens?
What they would do, you would put your information in on the National Association of Insurance Commissioners website. Since the National Association has no authority over the states, because every state is regulated by its own insurance department, this bill would require each company in the state to check that database quarterly and report back to the commissioner on a quarterly basis. So that way, if you put, let's say, for instance, your mother or your father in, you would know that it's going to be looked at least in a quarter, and they would report back to you if they have a policy active. This just simply takes it from a voluntary to a mandatory, and we put a sunset provision to go to 2024.
Thank you.
Okay.
You have no more questions.
Thank you, sir. Thank you, Mr. President.
Does any other senator wish to speak for or against Senate Bill 432? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. Ms. Secretary, can you please read the caption of Senate Bill 464?
Senate Bill number 464 by Senator Kennedy of the 18th and others. Bill to be titled an act to amend Title IX of the OCGA relating to civil practice so as to provide for uniform laws governing mediation and participants in mediation, provide for definitions, to provide for privileges against disclosure, admissibility, discovery, provide for fee for waiver and preclusion of privilege, to provide for exceptions to privilege, provide for confidentiality and mediator disclosure of conflicts and for other purposes. Mr. President, on March 5th, 2020, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted by Senator Stone of the 23rd Chair. That completes the order, Mr. President.
Is there objection to removing Senate Bill 464 from the table? The chair hears none, and Senate Bill 464 is off the table. The chair recognizes the senator from the 18th. For what purpose does the senator from the 55th rise?
Parliamentary inquiry, Mr.
State your
President.
inquiry.
Is it not true that the senator did not make a motion to remove SB 464 from the table? When?
I thought he did, but if he didn't, will chair for what purpose does the senator from the 19th rise?
President, I ask that we remove Senate Bill 464 from
Is
the
there
table.
objection to Senate Bill 464 being taken off the table? Chair hears none. The senator from the 18th is recognized to speak to Senate Bill 464.
Thank you, Mr. President. Colleagues, I bring to you Senate Bill 464, which is pretty...
We'll come back to order.
Colleagues, Senate Bill 464 very simply provides some statutory construct for us to be able to have uniform law commission rules or uniform commission rules for international mediation to take place in Georgia. What you have before you has been endorsed and vetted by the Georgia Bar Association, as well as the Atlanta International Arbitration Society. A lot of the states around us, in fact, most of the states around us, have statutes that deal with the construct for having mediations within their state, and those rules are set forth in their statutes. We don't have that, and because of that, there are lots of, we hope, lots of international mediations that could take place in Georgia, but they don't because the parties don't want to come to Georgia, conduct a mediation, and not know what rules would apply with regard to how the mediation has to be conducted. This simply closes that loophole, allows us to have these rules. These rules, as I said, are endorsed by the chair of the Committee on Dispute Resolution, the former chair of the Atlanta International Arbitration Society. This also comes from the language of the Uniform Law Commission, and I'm not aware of any opposition, and this will be a good thing for Georgia and a good thing for additional business opportunities for us here. Mr. President, I'll be happy to answer any questions.
You have no questions.
Thank you.
Does any other senator wish to speak to Senate Bill 464? Chair hears none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. We'll stand in recess till 4:30.